What have you written in the...
Sir, I have written English.
English, okay, let's speak in English. Now, you did your graduation from Ravenshaw in physics in the year 2015.
Yes, sir.
Thereafter, what did you do? Because you completed law in 2019. 4 years you spent on law course or anything else?
No, sir. I have done 3-year LLB course.
3 years?
LLB course.
LLB, you have done 3 years LLB course. Good. Thereafter, are you...
Sir, I have been preparing for civil services.
Are you practicing or something? Or
No, sir.
Okay. So your hobbies are playing and watching cricket, reading newspaper. That is
paper nature.
Sir, law.
Law.
Is optional.
Law.
Should I ask you some questions on law?
Yes, sir.
Constitutional law, IPC, CRPC.
Yes.
You know there was a previous provision in CRPC, which is normally called a FIRE, 154 CRPC. I am not very familiar with new ones.
Yes, sir.
There was a provision called how the FIR is to be received and prepared, wasn't it? 154 CRPC.
Yes.
In the new law relating to criminal procedure, what's its name? What replaces CRPC?
Sir, I am not aware about the
CRPC aguru thila bartaman
Sir, BNSS, Bharatiya
Bharatiya
Surakha Samhita.
BNS.
Bharatiya
Naya Samhita.
Bharatiya Naya Surakha Samhita, है
Sir, CRPC is BNSS has been converted to BNSS.
BNS. Now in BNS the FIR provision and the previous CRPC the FIR provisions, there is variance. What are the new things which has been added and why? Tell me.
Sir, I am not aware.
I am not aware from law graduate, no jan likhim the. Anyway, since you are there, I am telling you. In earlier provision, it was mentioned that if the officer in charge of a police station or SHO, as you may call it, if he receives an information about a cognizable offence, he will take it down, either investigate himself or send one of his subordinates to investigate. In the new BNS, I don't remember the corresponding provision, I am an old person. It is mentioned that there will be verification about the veracity or otherwise of the complaint or the information which has been lost. Okay, why it was so? Why this provision was added?
Sir, it has been added because there are numerous fake complaints have been filed by the
for unwholesome purposes, like giving a senior person, a politician or a judge or somebody, giving them a bad name by propaganda that a case has been registered, a FIR has been registered. That's right. So that is one thing. Tell me, under what provisions or what articles of the Constitution, okay, the scheduled castes and scheduled tribes have been given, or I mean basing on what articles of the Constitution, the scheduled castes and scheduled tribes have been given reservation and other facilities?
Sir, Article 15 and 16.
Tell me what is the provision in 15, what is the provision in 16?
Sir, Article 15 talks about that the state shall not discriminate on the basis of caste, creed, color and sex and place of birth.
Yes, and what else?
And sir, Article 16 talks about for the employment in public services, that there should be proper representation from marginal communities.
Marginal?
From SC, ST and OBCs.
What is the difference in the way reservation has been provided for by scheduled caste, scheduled tribes and OBC? What is the difference?
Sir, originally SC, ST reservation has been given in the Constitution. Later on, by Mandal Commission report, OBC reservation.
What is the constitutional provision? Can any reservation be given without a corresponding constitutional provision?
Yes, sir.
It can be given. So what is
Based
the
on
constitutional provision?
Constitutional provision.
Constitution provides for positive discrimination in favor of which community? And what is the difference why scheduled caste, scheduled tribes are getting promotion? On what basis OBCs are getting promotion? Anyway, briefly, बहुत समय नहो scheduled caste, scheduled tribes is for their long-standing discrimination and other things. Whereas OBCs are on their economic and social backwardness. Are you getting a point? These are the difference. Now, tell me, recently, under the by Tamil Nadu government moved Supreme Court that the governor is not reacting, keeping the matter pending with regard to bills passed by the assembly for indefinite periods.
Yes, sir.
The matter went to Supreme Court.
Yes, sir.
Supreme Court passed an order. There was also a presidential reference subsequently. What are the articles of the Constitution and what is the decision of the Supreme Court or where the matter stands now?
Sir, the article of the Constitution based on this topic
Yes.
is Article 200, 201 and Article 143.
Yes, 200, what is it say? 200,
Sir,
201?
it says when Assembly passes a bill,
Yes.
it goes by any state government, it goes by any state legislature, it goes to the governor for assent. The governor has three choices in that article, whether it can grant the assent to the bill, whether the governor can withhold the assent to the bill. Withhold assent to the bill. Also, the governor can, if he doesn't wish the bill as it is, then he can send it back to the assembly for reconsideration. Under Article 201, the governor can send the bill to the president for his reconsideration, for the recommendation of the president. And in Article 143, the president can seek advisory jurisdiction from the Supreme Court.
Yeah, there are certain shortfalls to it.
143.
143 presidential reference.
Is it binding on the president? Article 143.
No, sir. The recommendation of the Supreme Court is not binding upon
And
the
about
president to follow.
Supreme Court advice, day before yesterday there was a problem with regard to removal of a member of the Public Service Commission of Arunachal Pradesh. What is the provision of law, constitution, under Article 317? What is the provision? If a member of the Public Service Commission is to be removed, what procedural matters are available in the Article 317?
Sir, in that procedure, the matter should be sent to the Supreme Court.
Who can
for
remove?
inquiry. Sir, President can remove.
How he or she can remove?
Sir,
That is a specific
On
aspect.
whose recommendation or how it is, please tell
Sir,
me.
by the
State
recommendation of the
government has
Supreme Court.
recommended.
Yes, sir.
Okay,
Yes.
it has come to president, then president, why he is not removed? What is that bottleneck?
Sir, the President can act by the recommendation of the Supreme Court committee. And that
It will be
recommendation is
referred to the
mandatory.
Supreme Court to obtain opinion.
Yes, sir.
Supreme Court has found no evidence against the member and said that we are not bound to give you advice on this matter because we have not got any evidence against him, the candidate, Mr. Bage.
Yes, sir. So the Supreme Court opinion is
And
binding.
what
on the
is Article
President.
319?
So I am not able to recall the exact article at the moment.
A retiring member of the Public Service Commission, what will happen to his future? He retires at the age of 62. Cannot accept any employment.
Yeah.
So, but
That is
sir,
Article 319.
So there are some exceptions. He or she can be appointed as a member of UPSC or the chairman of UPSC after getting retired from state PCS member.
Yes, yes.
So I am asking you from constitutional law, since you have referred, we have heard about a case, Nanda Kumar Phasi. Janicho to Nanda Kumar Phasi?
Sir, I am not aware.
British Amal, Warren Hastings issue. Nanda Kumar was hanged for giving evidences against Warren Hastings and Supreme Court judge for some corrupt practices. So it was the original document. He was hanged despite a British law of 1729 that if somebody produces a fraudulent document, then you will be punished for 5 years, rigorous imprisonment. This was the law on the land of British, but he was hanged. And this particular matter was raised by Edmund Burke in the House of Lords, and it was recorded properly by Thomas Babington Macaulay, who has brought Indian Penal Code being drafted by him. What is the provision made by Thomas Babington Macaulay in the old IPC? Which provisions of IPC, sections of IPC looks into this matter of fraud, use of fraudulent document? Which sections?
Sir, section 420 of IPC.
No, 468 and 471.
Right. So finally one question of law, they will go elsewhere. Tell me, as you know in the constitution, there are state subjects in which states legislatures legislate,
Yes,
and there are central subjects. In which condition, and if it is a state legislature passes a bill in state subjects assented by the governor, isn't it?
Yes, sir.
Yes. And in central subject it goes to the president. Isn't it?
Yes, sir.
In which situation, even if a state subject, the matter after being passed by the assembly and looked into by the governor, it is sent to the president or union government for assent, where it is done.
Sir, if the matter involves to any public importance for national periphery.
Anyway, let's finish it and it's only where a central act, because there are many acts prior to 1935 which are central acts before the diarchy was introduced, but they still govern the state laws. Do you understand what I am saying or not?
Yes, sir.
So they are central laws, but under which the state subjects are governed in the state. In that case, the matter has to be referred to the union government and president. Okay, got it? Anyways,
ମୁଁ ଗୋଟେ ଖାଲି ପଚାରି ଦିଏ
ନା ଆପଣ ଲାଷ୍ଟ ପଚାରିବେ
ନାଇଁ ଏ ଯୋଉ କନଷ୍ଟିଟ୍ୟୁସନାଲ ଲ କହୁଛି ମନେକର ତମକୁ ପଚରା ହେଲା ଦେ ଆସ୍କ ୟୁ ଏ କ୍ୱେଶ୍ଚିନ୍ what is the difference between doctrine of pith and substance and doctrine of colorable legislation এই ল
it's a basic question la pith and it is a basic fundamental question pith and substance and
doctrine of
color
pith and substance and doctrine of colorable legislation
Sir, doctrine of pith and substance is the legislation which will follow the reasonableness and correctness of the matter rather than
so the judiciary looks into who has made the law, not that is the matter, but what is the pith and substance of the law.
so they will look into
That is the message.
Subject matter they will go to
And colorable relation means am mundu ko nako chuncho emiti buleigiri chuncho ki sidha chuncho seta nuhe you have made a colorable legislation to hide the original intention.
Sir, it was said what cannot be done directly cannot be done indirectly in colorable legislation.
ए जोड़ाक बर्तमान तो फेडरालिज्म उपरे आलोचना होची लॉ उपरे आलोचना होची सुप्रीम कोर्ट रे पड़ी रेफरेंस केसेस कैन स्टेट बी टेकन एज एन इंडिविजुअल अंडर आर्टिकल 32 Tamil Nadu government has looked into this matter from that point of view using article 32 of the constitution which is meant for citizens.
Yes sir, they can be party to the
Can state be treated as an individual enjoying article 32?
no,
That's
sir.
the issue. You are a student of law. Tell me.
No sir, article 32 about the
Right to constitutional remedies
yes,
available for Indian citizens
fundamental right.
the
can be
individual
suspended during emergency under article 359. That you can कही पार घाई 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 तुम लॉ पिला किंतु स्टेट जन इंडिविजुअल हिसाब से कैन द स्टेट यूज एंड द केस इज दैट ओके सर
ମୁଁ ତୁମକୁ ସ୍ପେସିଫିକାଲି ତିନିଟା ସିନ୍ସ ଆଇ ଟିଚ୍ କନଷ୍ଟିଟ୍ୟୁସନ୍ ଲ ତିନି ଚାରିଟା ସ୍ପେସିଫିକ୍ କଥା ମୁଁ ପଚାରୁଛି one of the ongoing issues is the issue of sedition law.
yes.
Sedition. ମୁଁ ପଚାରିଥିଲି question ଟା ବି. So what was the earlier law and what is the present law and what is the challenge to this which is now will be heard by a constitutional bench. Listen to me. Also, you kindly tell me that what is the Supreme Court judgment which gave a judgment on sedition which is still valid and that is under challenge now. Have you understood the question?
Yes, sir.
First, tell me the difference between the sedition law earlier and the sedition law as per BNS. Then you kindly tell me what is the judgment which is still relevant as far as sedition law is concerned, which is under challenge because some of the journalists have written about this Operation Sindoor. So, editor of digital paper has written, it is already on the TV, and so you explain to me.
Earlier, under the sedition law was mentioned in IPC under article, section 124A.
What are the provisions?
It says when an individual does any incitement to hatred or contempt or any disaffection towards the government, then the government can take action against the individual.
Section 152 re kon ache?
It talks about if any individual goes against the unity and integrity and sovereignty of the nation, then the state can take action.
So what is the difference in the tenor between the two?
Earlier sedition law section talks about offense against the government.
Okay.
Here in 152 BNS it talks about offense against the country.
Against the country. So what was the judgment which is under challenge now?
Sir, the judgment,
sir,
it was in 1962, I guess, Kedar Singh judgment, which validated the sedition law.
But they also gave a proviso there. There was a judgment. There was a proviso to that judgment. It was not an unqualified judgment. They had said that while sedition law is valid, they had said something. You can invoke sedition law on which ground? That said a very important thing. Incitement to violence. Incitement to violence. Incitement to violence. Sedition law will apply only when it is inciting.
Constitutional regime in India is read by 28.
So what is that the Supreme Court in the initial hearing, what Justice Suryakant gave some, so what is he trying to say? But what is the prima facie observation of the Supreme Court on section 152?
28.
Sir, as per the opinion of Justice Suryakant about the current BNS article section 152, he talks that it was quite vaguely worded. It can be misused by the government.
Okay. And there is
it will be a chilling effect on freedom of speech.
This is exactly the whole thing. Now tell me that whenever there is a reasonable restriction which is imposed by the government under 19(2) and there is a challenge in the Supreme Court, they apply a test which is called the proportionality test.
Yes, sir.
They apply a test called the proportionality test to find out whether the restriction is reasonable or not. What are the three elements of the proportionality test? What is that the Supreme Court will see? This is a real deep question for somebody who has done law. Or is it something? This is a basic question for a law student.
Sir, I don't remember the exact.
Proportionality test is a major thing.
Sir, if you allow me, I can make a try. Yes.
Sir,
I think they will go to each and every case to look into the matter whether it.
No. In the proportionality test, they will go about it in 3 steps. First, whether it is a valid law. Tapare second one dekhibe whether there is a nexus between the objective and the act. जो objective अच्छी तार consequence whether there is a linkage. जिनते आधार केस रे. So से कहले से तमर objective हला जे तमे जो duplicate PAN cards अच्छे ना नहीं सेटा तुमे trace करो चाहूँ. So if you are insisting on somebody's Aadhaar, the objective is जे तमरो माने duplicate PAN card नहीं तमे problems करूना. So सेटा होचे nexus. And third है जे whatever action the government state takes, whether it is disproportionate or proportionate, माने whether the whole thing could have been done through a lesser tool or a lesser objective or a lesser objective. So ଏଇ ତିନିଟି ପଢିଦେବେ proportionality test. ଗୋଟେ final question ଆପଣ ପଚାରୁଛି, ଆମେ ଯୋଉ କହୁଛେ due process of law ଆଉ procedure established by law, ଏଇଟା ଯେତେବେଳେ ଆମେ ଆମେରିକାର ନେଲେନି, କାହିଁକି ନେଲେନି? Why did we not apply the due process of law and why did we go for procedure establishment and what is the difference between the two? And last question होची इतरे जे is the Supreme Court following the procedure established by law or in many cases actually it is following due process? And many people say the Supreme Court practices de facto due process of law. This is a question which comes in the civil services. You have to cite also case.
Along with that, one I'll add, has the Supreme Court looked into this matter from this angle that procedure established by law is subsumed in due process of law?
Absolutely. से तारा पूरा complete कर दले हाँ.
Sir,
बुझी पहले कथा?
Yes sir. Sir, procedure established by law means we should follow the law as it is stated or passed by the legislature or parliament.
And whether it has been done, whether it is implemented as following a procedure. किसी आपको कहाँ को notice दले की? Whether you have just gone through the motions of a procedure. It all a procedure established by law. Due process
of law is we should look into the correctness or the reasonableness of the issue.
Does it lead to evidence based law in India? ଆମର ଯେଉଁ କଥାରେ ଅଛି 100ଟା ଦୋଷୀ ପଛେ ଖଲାସ ହେଇଯାଆନ୍ତୁ ଗୋଟେ ନିର୍ଦ୍ଦୋଷ ଦଣ୍ଡ ନ ପାଉ. Procedure established by law hints towards that. संविधान को आर्टिकल procedure established by law mention अछि?
It's a basic article.
Sir,
which article mention?
बहुत basic है.
Article 21.
हाँ, और इतने
right to life, personal liberty. Yes sir. So then
को केस रे सुप्रीम कोर्ट पहला ड्यू प्रोसेस ऑफ लॉ जो कोच है de facto introduction of due. This is a famous case.
Sir, Menaka Gandhi case. Sir, then I was talking about the due process of law. They will look into the reasonableness and correctness of the matter.
Good. I'll put out.
Sir, another thing I want to answer of your question about whether Supreme Court follows due process of law or established by law. Sir, de facto, the Supreme Court is following due process of law.
Yes.
In its judgments.
Yes.
Over the years.
Yes.
ତମେ ଯାହା କହୁଛ ଦାମରାଉ ତ କଥା ଭଳିଆ କହୁଛ. ନଈକେ ବାଙ୍କ ଦେଶକେ ଫାଙ୍କ. ତାର ପ୍ରତି 3 ଦିନରେ ଏଇ କଥାଟା ସେ କହିବ ଷ୍ଟେଟମେଣ୍ଟ. ସେମିତି କ'ଣ ତମେ ଲ ପ୍ରଡକ୍ଟ ରିନ୍ୟୁଜ୍ ଟୁ ଲ କରିଛ ନା କୋଉଠୁ?
Yes sir.
ତେଣୁ ତମର ଏମ୍ଫାସିସ୍ ଦମଦାର କଥା କହିବ ନା. ଆମେ ଟିକେ ଆମେ ପେରିଫେରାଲି ଜାଣିଛୁ, ତମେ ତ ସେଣ୍ଟ୍ରାଲକୁ ଯାଇଛ ନା. ହଉ
ठीक है.
आर्टिकल 20 ଆଉ 22 of the Indian Constitution, ତା ଭିତରେ ଡିଫରେନ୍ସ କ'ଣ?
अब कोड़े खाली गोटे मु कहूँ गोटे इम्पोर्टेंट सुप्रीम कोर्ट जजमेंट कहले आर्टिकल 20 को रिलेट करके गोटे इम्पोर्टेंट सुप्रीम कोर्ट जजमेंट कहले.
Article 20 subclause 1 talks about there should be no ex post facto law in India.
22.
20 subclause 1.
But double jeopardy is there in Article 20. 22 रे कौन होची?
22 रे अछि there should be no
सेटा अछि यांको पे right to free trial, fair trial. Right to fair trial.
there should be preventive.
सेटा काहा को लीड करछि CRPC रो?
गोटला नॉर्मल डिटेंशन और गोटला प्रिवेंटिव डिटेंशन. इट मेक्स अ डिस्टिंक्शन बिटवीन नॉर्मल डिटेंशन एंड ए प्रिवेंटिव डिटेंशन. आउ गोटे हला जे दैट आर्टिकल 20 fortifies you against giving an evidence against yourself. But that
person can be give evidence or can be
Against
forced
himself.
against himself or herself. Self recrimination बोली कौचे इटा गोटे केस रे सेल्वी केस रे जो थे तको फोर्स करथले माने लाई डिटेक्शन टेस्ट पे इधर सुप्रीम कोर्ट करते का फोर्स कर परिबेनी आपन को लाई डिटेक्शन सब ई जो इंपोर्टेंट आर्टिकल उडा गला गोटे गोटे देखिए केस लॉ टिके देखिए
ठीक को
तब को
परफॉर्मेंस ऊपर कोन सुनत आपनकर यू हैव ओनली लॉ डिग्री एंड नथिंग एल्स so they will ask you too many questions on various legal
ए भले पचे
points जोड़ा अछि हम इंडिया रे which has been relevant as sir management
बहुत इंप्रूव करछ जहा लास्ट पे चतली
तापरे we could not ask you many things about
current affairs
general studies with regard to Odisha India and in international sphere so what I will strongly recommend is आपण टिके लॉ गुडा तो भलो की पढिबे देखि नियंतु लॉ रो को पॉइंट गुडा को जो पॉइंट नॉर्मली केतोडा कथा कहले तापरे ए जो पॉइंट गुडा सदाबे डिस्कशन हुए जोडा फंडामेंटल राइट रो माने ये पॉइंट गुडा को इंपोर्टेंट पॉइंट गुडा डिस्कशन होची कॉन्स्टिट्यूशनल लॉ रो जो पॉइंट गुडा डिस्कशन होची तापरे भलो की पढि देथिबे हैला जोडा वर्तमान आछि ए जो नुवा एक्ट गुडा के जे बीएनएस आ दुटा नुवा क्रिमिनल एक्ट वेदर तार किछि इंप्रूवमेंट ऑन इट और व्हाट इज इट्स रेलेवेंस ताकू भी पचार दी पारन से विषय आपण
पचर
प्रिपेयर ही के आसबे तो टिके एमाने सर्कुलेट करछन इंस्टीट्यूट सर्कुलेट करछि
और टिके मन रखियो प्रोहिबिशन आ सरसरी सेमान पचारते गत वर्ष पचारथिले ता भीतर डिफरेंस कोन प्रोहिबिशन एंड सरसरी ऑफ आर्टिकल 32 फाइव रीड प्रोविजंस अछि application part prohibition and sorcery
the prohibition is when a higher court prohibits a lower court to not to exceed its jurisdiction
for lack of jurisdictional
authority
or कौन सेटे काहे मना करियो
jurisdictional territorial authority
तापर sorcery रे
they direct the lower court to not to exceed
whether prohibition between prohibition and sorcery which one is administrative
sir sorcery is administrative
को मनी
हाउ थैंक यू
yes thanks
hey
आपण होइला
कौन ए सेठी बसिले बोली बचैबेनी
जे ता पाके नाही एटा तार नाही
साइलेंस ऑफ द
ठीक अछि ऑल द बेस्ट
टे भल के देखि देबो आजि काले जो चलंती आईन जोटा चलीची मनकर काली केरल गवर्नर केस करिची कोन ना चीफ मिनिस्टर बसिबनी सिलेक्शन ऑफ वाइस चांसलर जो कमिटी रे बसिबनी ये कथा जे कॉन्स्टिट्यूशन लिखता कोन भाबिथिला एमति हबो
sir can I say something so the governor apply the
अरे सिस्टम ता तयारी कलो गोटे यूनिवर्सिटी के देलो ऑटोनॉमी देलो तार चांसलर हला गवर्नर ममता बनर्जी को से कि मु चीफ मिनिस्टर मु हेबी चांसलर से ही परिबनी ए कहि के झड़ी के झगड़ा को समाधान करिवो
sir they follows the
and we are engaged in more silly matters than the constitutional matters काली केरल गवर्नर जाईची सुप्रीम कोर्ट
yes sir
जे चीफ मिनिस्टर बस परिबनी
जो गुटे सिलेक्शन ऑफ वाइस चांसलर पे दे हैव नॉमिनेटेड a retired supreme court judge so governor has no problem on that
yes sir
but governor has a problem जे सब माने सीएम टा बसिबनी सेतरे
CM's recommended candidate should not be
they CM should not be part of the recommendation not recommended candidate से माने जो recommendation करिवे से he should not be in that committee
चांसलर को की
नहीं
चांसलर
माने कॉन्स्टिट्यूशन लिखितले कि जो माने ये प्रोसीजर यूनिवर्सिटी एक्ट भरिका तयारी करते यूजीसी गाइडलाइन अनुसार से माने लिखि पारथांते गवर्नर स्ट्रोक चीफ मिनिस्टर स्ट्रोक एजुकेशन मिनिस्टर लिखि पारथांते एटा कथा कहबो जोटा वर्तमान राहुल गांधी कहि बोलुची जे ए ज्ञानेश शर्मा भरिका जो हेचंती से सब ठीक न सुप्रीम कोर्ट कहता जे चीफ जस्टिस ऑफ इंडिया विल बी ए पार्ट ऑफ द प्रोसेस ऑफ सिलेक्शन ऑफ इलेक्शन कमिशन
yes sir
कहितला
yes sir
कौन कहितला ता धेले कौन कहितला से आईन ता लेखा हिजला नै से मूर्ख सेगडा को लेखा हितला जे टिल ए लॉ इज मेड बाय द पार्लियामेंट दिस प्रोविजन विल कंटिन्यू एटा कोन समान पढनांती किंतु बट गोटे नैरेटिव क्रिएट करा होची जे सुप्रीम कोर्ट जज को काट दियाला मु गोटे टेलीविजन डिस्कशन रे कहितली मु कहली इफ द लॉ मिनिस्टर ऑफ द कंट्री इज अनसुइटेबल affects the separation of power when he is a member of the Judicial Appointment Committee, law because he is a political man, why should be judicial? Arpre court ko jibo case jodi bhul heitibo.
he is not law officer, he is part of the government. What a separation of power is.
appeal ta kabe karibo jodi chief justice basila eti appeal kemiti habo against the selection. Chief justice jodi member hela selection committee ro appeal kothi karibo same bhagwan ko pakare.
सर मोर टिके
ये
पर्सनल
जिनस गुड़ा मूल मूल जिनस
डिफरेंट ओपिनियन
आम आईन रो मूल जिनस गुड़ा
सर मो मतरे जेमति
we
सीबीआई
are using more of political tantrums
प्राइम
than
मिनिस्टर
judicial
लीडर ऑफ अपोजिशन आउ सीजीआई रहिबे अपॉइंटमेंट कमिटी सो दैट देयर विल बी नो अथॉरिटेटिव रेड बाय सीबीआई ईडी और any other agencies against political opponents. I think similarly in election commission appointment also CGI should be made a part of the committee. And if you after that we made a law, a union minister was included by excluding
अरे
the
से
CGI.
ज्ञानेश शर्मा
No, not
सुनो
law minister, home
ये
minister.
कहिबे सत्य
Home minister,
ज्ञानेश शर्मा
not
कौन
law minister. Ganesh Kumar.
ज्ञानेश कुमार कौन सी डिफेंस सेक्रेटरी था
नहीं से जॉइंट सेक्रेटरी था हां
जॉइंट सेक्रेटरी था से जो हेलिकॉप्टर किना केस रे
आज्ञा।
से तार फाइल कोन नोटिंग देता से नोटु था ऊपर बिगड़ी की रखी राहुल गांधी से जेहेतु सेठी लेखितला से इलेक्शन कमिशन को एस्पिरेंट से नोट ऑफ डिसेंट देछि नोट ऑफ डिसेंट देले कोन आलसु दी जण तीन जण मेंबर तादु दी जण कहिबे मेजॉरिटी तू जो विरोध दीपाले
କିନ୍ତୁ ଯେହେତୁ ପ୍ରାଇମ ମିନିଷ୍ଟର ଆଉ